Good morning and welcome to the Shenkman Wealth Management Accountant Attorney Fall Webinar Series. This program is entitled Safeguarding Wealth from Predatory Litigation. For those who don't know me, my name is Jonathan Shenkman. I'm the president of Shenkman Wealth Management. In that role, I work as a financial advisor, portfolio manager, and serve as a fiduciary to my clients to help them achieve their financial goals. The goal of all my programs is to bring professionals together to help them better serve their clients. This is done by educating attendees on the latest topics in wealth planning and by encouraging collaboration between a client's attorney, CPA, and financial advisor where appropriate. My practice focuses on working with high net worth families, businesses, and not-for-profits. I manage individual investment portfolios, trust accounts, corporate retirement plans, and endowments to help my clients achieve their financial goals. In addition to the 25 or so events I run every year, I also do a fair amount of writing on the topics of investing and financial planning. You can read my work in Barron's, Bloomberg, CNBC, Fortune, Forbes, Kiplinger, the Wall Street Journal, the CPA Journal, Trust and Estates Magazine, U.S. News and World Report, and many other periodicals. After the program, I'll send out a link to all the publications where I publish my work. One more quick note before I introduce our esteemed speaker. The handout to this program was sent out within the reminder email this morning. It will also be sent out again in the follow-up email tomorrow morning as well. Today, we're privileged to hear from Eli Akhavan, partner at Steptoe and Johnson, based in New York. Eli is a partner in the Tax and Private Client Group, where he counsels clients on sophisticated domestic and international wealth structuring, including advising high net worth individuals, families, family offices on their tax, wealth preservation, and estate planning needs. Eli also has considerable experience in establishing domestic and foreign asset protection trusts, business succession planning, and charitable giving. Additionally, he specializes in advising cross-border clients on foreign trust, pre-migration, and expatriation planning, and on planning for the purchase of U.S. residential and investment real estate property. He also has considerable knowledge on the reporting requirements applicable with respect to foreign financial accounts and assets with respect to FATCA and its global equivalent, the Common Reporting Standards. Today, Eli will be speaking on safeguarding wealth from predatory litigation. And with that introduction, I'll now turn the program over to Eli.
Thank you, Jonathan. It's always a pleasure to work with you both on a professional level as well as collaborating on educational and formative events such as this. Good morning, everybody. Thank you for joining today. My name is Eli Akhavan. As Jonathan mentioned, I am a partner in Steptoe and Johnson's private client and tax group. My expertise focuses on high net worth clients, on tax and estate planning for high net worth clients, under asset protection planning, on representing family offices, in their succession planning, and overall protection and safeguarding of wealth for high net worth and ultra high net worth individuals. Today's topic is titled Safeguarding Wealth from Predatory Litigation. In times of economic uncertainty, when there are events that cause us to not be able to predict the markets or to know exactly which way the stock markets are going to be going, what's going to be happening in the overall economy. We all hear from different pundits, read different articles. I'm sure most of you, if not all of you, have subscribed to Jonathan's newsletter, which is very informative. But there's always a bit of uncertainty out there. And with the uncertainty comes worry about how to safeguard wealth. And additionally, with uncertainty comes more litigation, because people become more protective over their money. They may believe that they're entitled to more money that they really are entitled to. And that always leads to more litigation, especially to predatory litigation. Today's webinar, I'm going to be focusing on how people who have earned hard-earned wealth, whether it's $1 million or $100 million, how they can put particular plans and vehicles in place to safeguard and to protect those assets from future potential creditors, from predatory creditors, from divorce, from tort creditors, from business lawsuits, etc. first, we're going to discuss a bit of exposure of private assets to litigation. So within that, we have to understand what is the fundamentals of asset protection planning. And the way many practitioners define it, the way I approach it, is where one structures their ownership to their assets to protect those assets in part or in full from future potential creditors. Let me discuss a bit what I mean by that, and the words that I chose, I selected carefully. Structuring ownership means putting ownership in one's name, putting it in joint name, putting it in a trust name, in a business entity name, as I'll discuss, into sophisticated trusts such as domestic asset protection trusts, to put it into certain types of life insurance policies, again, for protection benefits. That's what I mean by structuring ownership, to protect in part or in full. I'd like to emphasize that any form of asset protection planning, at the end of the day, is not bulletproof. There's no one magic solution that will bulletproof and completely shield one's assets. There will always be a bit of exposure, but a good plan, A, does protect in part at the very least, and B, incentivizes potential creditors to settle. Because when a potential creditor comes and sees that the assets are wrapped up very nicely and placed very nicely in particular vehicles, such as trusts and entities, they are more likely than not to settle for cents on the dollars. So that's what I mean by protect in part or in full. Finally, and this is the part that I would like to emphasize the most, if there's one thing to take away from this webinar, and that is to protect from future potential creditors. If an individual has a current creditor, or there is a current judgment, or even if there's a current lawsuit against them, if they engage in transfers to certain types of vehicles, and if it is not done properly, and we'll get into what I mean by done properly, these individuals will be subject to what are called the fraudulent transfer rules or the voidable transfer rules. Essentially, if a judge sees that a transaction was done to delay, hinder, or avoid creditors, that transaction will be unwound. At the minimum, at the maximum, there could be civil liability implications. There could be criminal law implications, especially in the context of bankruptcy. But it is very important to know if there's a current creditor, you got to be very careful in terms of what type of transfers you are allowed to make. If there are no current creditors and you're trying to protect from future potential creditors, that is the best position to be in. And I'll discuss that a bit more in a couple of slides. Let's go just through the who and why of asset exposure. Activist judges. There are judges out there that are constantly coming up or validating different theories of liability. It could be against real estate professionals, it could be against real estate developers, condo developers.
Eli, I don't mean to interrupt you, but your slides aren't moving. So if you're able to get them to change, that's great. If not, just keep going with
what slide do you see now? Do you see
just the first one? The first one, it hasn't changed yet.
Oh, they're moving on my screen.
It's a short program, so everyone's going to get this. Everyone's going to get the slide deck afterwards, so I don't want to spend too much time on this. But if you're able to fix it quickly, great. If not, just continue talking.
Okay, yeah. Thank you.
Sure.
The who and why of asset exposure. As I said, activist judges. That's one who are coming up with theories of liability. Who is exposed to asset creditors, business owners, real estate professionals, fiduciaries who are executors and trustees, condo developers, as I mentioned before, professionals, attorneys, accountants, architects, engineers, persons involved in a car accident, parents of minors. I do see this coming up a lot. A parent allows a minor to hold a party in the house. Somebody's injured because of that. Somebody walks away drunk because of illegally obtained alcohol. So parents of minors are exposed there. Environmental liability. If somebody, real estate professional owner, engaged in some sort of transaction and there was environmental exposure or toxic environmental exposure there. Parties to a divorce, that comes up a lot also in terms of asset exposure. Family disputes in a business. Again, these are all types of liabilities that are out there. And of course, just run-of-the-mill tort litigation and business litigation. These are instances that are out there that happen a lot, and that people need to protect themselves from. Now, what does proper asset protection planning consist of? Well, the planning spectrum really depends on one's assets, and it ranges at the most basic level from umbrella insurance to the most sophisticated, which involves foreign asset protection trusts, as well as associated vehicles with those foreign asset protection trusts. So let's discuss some of the more traditional forms of asset protection. There's, of course, umbrella insurance. That's the most basic that every individual should have. There's entity planning, and most business owners are familiar with this. If don't conduct business out of a sole proprietorship, have some sort of entity wrapper for the business. Exemption planning. There are certain types of assets under both state and federal law that are protected by statute from creditors, and we're going to get into some of those assets and what they are. And again, it's a state-by-state basis. Vanilla trusts. These are the term that I use. These are vanilla trusts that people use for estate tax planning, for some sort of creditor protection planning. It's based on the law of one state, and they provide some level of protection. The next level to go to are domestic asset protection trusts. And these are trusts that are settled in what are called self-settled states. There are currently around 20 of them on my last count. And these are jurisdictions that allow an individual to put their assets into a trust, remain a beneficiary of principal of the trust, but at the same time have those assets be protected under that jurisdiction state laws from creditors. And we can discuss a bit of that. And finally, what I do a fair amount of are foreign asset protection trusts. And these are trusts that are settled in a myriad of options offshore outside the US with a foreign trustee that really do provide the maximum protection. And I'll discuss a bit of the pros and cons of these different options, and you can determine what's appropriate for you, for your client, etc. The first type of planning that I mentioned, or the most fundamental and basic level, is umbrella insurance. Umbrella insurance, you go to your insurance agent, you ask them for a general coverage. Both this should cover personal liability up to any amount that you really ask for, $1 million, $5 million. And it's really a general liability vehicle. Now, this is a great tool to have for any business owner, for any professional. It's very prudent. And the great part about it is that it's extremely cost effective. It is the cheapest way to have some level of asset protection. The drawbacks of umbrella insurance, or should I say the weaknesses of umbrella insurance, is that there are coverage limitations, A, and B, there are also policy exclusions. There's certain events that are not accounted for. Again, say divorce, say a general contractor issue, say something that a minor child did. There could be a bunch of coverage exclusions that when you first buy the insurance, you think you're completely covered, but you're not for all instances. And those are the weaknesses. That is not to say that one should not have purchased umbrella insurance. They should have it, but sometimes it's not sufficient for a particular client's needs. Entity planning. That was the next item that I mentioned as an important part of asset protection planning. Entity planning really involves what I'm referring to as corporate and partnership vehicles. So these are Incs, INCs, corporations. These are LPs, LLPs, LLCs, the whole variety of the alphabet when it comes to partnership vehicles. When conducting a business, it is very important to operate out of one of those two vehicles. And the reason is because that vehicle insulates the owner from, or insulates the owner's other assets and personal assets from the operations of the business or any liabilities from the operation of the business. Now, to which form of entity to use, whether a partnership or the corporate form, these are all involved tax considerations as well as non-tax considerations. So you can certainly speak with your accountant or your tax attorney about what is the best form of entity for a particular business and particular purpose. But as a general rule, always better to operate out of an entity. One important part of that I wanted to discuss, and I get this question a lot, is to distinguish between inside creditors versus outside creditors. So let's say an individual is operating a ski resort out of a limited partnership or an LLC. Any liabilities that happen due to that ski operation, the ski lift operation, let's say somebody falls off, somebody's injured, etc., the injured party can reach any of the assets within the LLC. Or let's say somebody owns a building in an LLC. Somebody gets injured, there's not sufficient insurance coverage, or there's a contractor that gets injured, you didn't cover, then the owner didn't have sufficient insurance coverage. That injured party can reach any of the assets within the LLC or within the corporate entity. What they cannot do is they cannot go outside the entity and reach the individual's personal assets. So there is still some level of exposure there. Now, what are outside creditors? Outside creditors are, let's say you have that individual who owns the ski resort in an LLC, so owns 100% of an LLC, but they injure somebody else in a car accident. That injured party in a car accident that has nothing to do with the ski resort can come after the assets of this individual. And one of those assets is the LLC ski resort, okay? That individual is an outside creditor, and they could again come after that LLC interest with certain limitations. And that limitation is, that I've noted here on the slide, if you can see it or if you've printed out handouts, is the charging order protection. The charging order protection says that for partnerships and LLCs, the creditor can only come after the economic interests of the partnership. They can't step in and become an actual partner of the LLC. They can only step in and obtain any distributions that would have otherwise been distributed to this partner. They can be entitled to that. And that's called charging order protection. And some states have charging order protection as the exclusive remedy for that creditor. So when it comes to entity ownership, yes, it does provide certainly levels of protection, but that charging order protection can be exclusive or it can be non-exclusive depending on the state that you're in. And then second, what we need to be very cognizant of is that the operating agreement for this entity must be properly drafted, must have asset protection provisions and features within it in order to make sure that the charging order protection works the way it should. So that's why many times, if most of my clients come in, they have some sort of form operating agreement that either somebody else prepared for them or they download it off Zoom. That's not going to work in the real estate arena. It's not going to work in other arenas of business for asset protection unless it's properly drafted and has the correct provisions in there. Respect the entity form is so important that for entity planning, the entity is not treated as a personal piggy bank. Obviously, the owner can take distributions from it, but they should not be paying personal expenses out of that entity. They should first distribute the money to themselves, and then use those for personal expenses rather than using the entity form as a personal expense bank, because otherwise a judge will disregard or can disregard that entity form and thus eroding the asset protection benefits. It's very important to segregate assets. So again, the example that I like to use is a ski resort. So if that ski resort owns real estate and it also has ski operations such as the lift, such as the equipment, etc., segregate those into two separate LLCs. Because if somebody gets injured on the ski lift, the most we want them to come after is the ski equipment or the ski lift machinery. We don't want them coming after the real estate on which everything is held. So you need to bifurcate, you need to segregate the assets of real estate and non-real estate assets. And that goes for all types of businesses, whether it's a professional corporation, whether it's an accounting firm, a law firm, etc. Always segregate real estate and non-real estate assets. Now we'll go to the next level of exemption planning, and that's for exempt assets. As I mentioned, there are federal and state protection for certain exempt assets. I'm going through a few of the famous ones. I'll note them. Life insurance and annuities. New York, for example, has robust laws protecting life insurance policies and their proceeds from creditors, as long as the funds used to purchase those vehicles, such as life insurance and annuities, were not fraudulently obtained. But that's one example. Retirement assets, another example of protected assets. And again, these are public policy considerations by each state to protect these assets. Finally, for our purposes, Homestead is the most famous one, where one's home or primary residence is protected from creditors. Now, the most famous one we know of is Florida, that has unlimited homestead exemption. O.J. Simpson, decades ago, he went and bought himself a primary residence in Florida and claimed that that's his homestead, so he protected from lawsuits and judgments. Funny enough, and most people don't know this, New York also has a homestead exemption, but it's not unlimited. I think it's a little bit below $200,000 or around there, depending on the county you live in. But that equity is protected from creditors as well. But it's important to note those as part of the overall plan. When the client comes to me to assess their exposure and to see how best or how to better protect them, these are just some of the fundamentals we go through. Vanilla trusts. These are trusts that we set up day in and day out for clients. These are irrevocable trusts. Revocable trusts do not have asset protection benefits. They don't have tax benefits. Revocable trusts merely avoid probate. However, irrevocable trusts, if properly structured, can and do protect from future potential creditors. What we usually do is we have a settlor, the one who settles the trust or who contributes the assets to the trust. They put the assets in the trust, let's say for a spouse and descendants. The spouse and descendants are protected if the trust is drafted properly from their creditors. The settlor himself or herself is also protected if they transfer these assets before any judgment or creditor was on the horizon. So those are assets that we certainly, that's a vehicle we certainly use for asset protection. The settlor, this is very important, cannot be a beneficiary of that trust. They may be able to borrow against the trust. There's certain provisions we can put in to provide access, but they can never be a beneficiary of the trust. Otherwise, they'll be exposed to creditor claims. There are three types of what I call the fraudulent transfer laws. There's fraudulent conveyance laws, fraudulent transfer, the Voidable Transfer Act. These are which is becoming more in vogue these days with states all over the U.S. Essentially, it says that a person, I'm really simplifying this, these bodies of law essentially say that a person cannot transfer assets to avoid, delay, or hinder creditors. There's a statute of limitation in each state for these. 6 years, New York is 6 years. In designing the irrevocable trusts, it's very important to avoid mandatory distributions in the trust. So there are a lot of trusts that I see that say mandatory distribution of income, 10% of the income every year shall be distributed to the beneficiary. Or I see At age 35, 1/3 of the trust assets go to the child, and then another third goes into, at age 40 goes to the child, and the balance at age 50 gets all distributed to the children. I don't generally like that. I don't recommend that. The way I draft is they remain in trust forever unless the trustee wants to distribute it to the child. I leave it in the trustee's discretion. The child or the beneficiary can remove or replace trustees, but at least the assets are within the trust wrapper. That's what I generally recommend, because we don't have a crystal ball. We don't know what the future is going to look like. We don't know if there's going to be a divorce with the child. We don't know if they're going to be sued in the business. We don't know if they're going to have a car accident. Whatever it is, we like to have trusts wrapped up. And in assessing a client's exposure, I review the trusts of which they're beneficiaries of. I review the trusts of which their spouse and children are beneficiaries of, just to tighten up and make sure they are fully protected. And of course, it's important to have an independent trustee in there, either as the sole trustee or as a co-trustee, just to make sure everything is well protected. Domestic asset protection trust. So a DAPT, in short, is a trust that's settled in one of the 20 jurisdictions in the United States where there is creditor protections for the settlor, even if the settlor is a discretionary beneficiary of the trust. So certain states have said a settlor is allowed to put their assets into the trust, remain a beneficiary of principal, not of income, but of principal of the trust, and those assets will still be protected from the creditors of the settlor. Again, assuming there's no fraudulent transfer or conveyance. Now, this type of trust works really well for clients who want the protection, whether it's estate tax protection or creditor protection, but they quite don't want to give up the full control, and they still want to be able to have that asset back in their name. This type of trust is terrific for those purposes. There are a few issues with these trusts, however. They're not the nirvana. And by the way, the most famous trusts or jurisdictions are Alaska, Delaware, South Dakota, Nevada. Wyoming's becoming more and more popular these days, especially among my West Coast clients. So these are trust jurisdictions that allow somewhat of having the cake and eating it too, but not completely. A local trustee is required. So if somebody's in New York, they can't just set up a Delaware trust and just call it a Delaware trust and have the protections. They need a local Delaware trustee. There are a lot of local trustees and corporate institutional trustees that can be used for these purposes. There are enhanced asset protection features to these trusts. So Nevada protects from marital claims. There's shorter statute of limitation periods. So for fraudulent transfer in New York, we have a 6-year statute of limitations periods. Some of these jurisdictions have 4 years, others have 2. But you've got to review them carefully with an advisor just to make sure to select the best jurisdiction given a particular set of circumstances. Part of asset protection aside, that it's not a bulletproof mechanism. Asset protection, another feature is that it's really more of an art than a science. Yes, you have to know the laws and be very well versed in the particular features of every state, but it has to be customized to the client's circumstances in particular. There are exception creditors in some of the states. So say for child support claims, alimony claims, etc. Some of these states have those exception creditors. Two of the bigger weaknesses with domestic asset protection trusts are constitutional issues. Actually, there's a full faith and credit clause issue, which means that, let's say you are, in short, the conflicts of laws issue as well. But in short, what that means is if you're a New York resident and you have a New York creditor, but you put your assets in a Delaware trust, which laws apply? The New York laws, the Delaware laws, the Nevada laws, whatever state you put it in, which laws apply? And second of all, if you get a judgment in New York, if a creditor gets a judgment in New York, can they enforce that against a Delaware trustee or a Nevada trustee, whatever the case may be? That's one of the weaknesses of domestic asset protection trusts. And there's not a lot of case law out there on it. So, which does show, by the way, that they seem to work to a certain extent because they never got to the point of case law. They were probably resolved and settled outside of court. One important part about domestic asset protection trusts, they're not suited for real estate. So if an individual owns real estate in New York, they want to transfer it to out-of-state trust, it's not going to work for real estate. It's great for liquid assets, just a business interest, as well as stocks and securities. I see it's on the hour 9 a.m., but I just have one more slide to go through, and I'll finish it up in a minute or two. Foreign asset protection trust. This is what I would call the highest level of asset protection planning on the spectrum. These are trusts that are governed by the laws of a foreign jurisdiction. Nevis is one, Cook Islands, Liechtenstein. There's a myriad of options you can choose for foreign jurisdiction. But again, you need a good review of those about which one would be the best. The strongest point of a foreign asset protection trust is they're not subject to U.S. court jurisdiction. A U.S. court can't ever touch those assets. They're not subject to U.S. constitutional law issues, such as I mentioned, full faith and credit and conflict of laws. They sometimes require a higher standard of proof to prove fraudulent transfer. A bond is required if a creditor wants to come after a creditor. If a creditor wants to come after a debtor on a judgment, they have to post bond in that local jurisdiction. Cost is a big consideration here. These trusts don't come cheap, but they may provide a lot of benefits. A foreign trustee is required. You got to have a local trustee there. You got to work out a way how to invest those assets. They provide a nice diversification into foreign investments, etc. For U.S. individuals setting up foreign trusts, tax filing and reporting obligations are there. There's a file. There's a form 3520, 3528. There's a bunch of forms that need to be filed. Again, asset protection is not about concealing or hiding. You got to disclose everything, but at least they'll be well protected. So that's why also tax reporting becomes very important. Otherwise, there's severe penalties. There are some challenges to offshore trusts. One is the optics, of course. Two, contempt of court proceedings. There are many cases out there, bad fact cases, frankly, where if an individual transfers assets to a trust, a foreign trust, after a judgment, and claims that they can't access the assets, a judge will sometimes hold that individual in contempt of court and throw them into jail until they repatriate the assets somehow. There was a case of a person was getting a divorce. I believe it was in Ray Lawrence, and they put their assets into a foreign asset protection trust. Judge threw him into jail for 7 years and didn't buy his claim that they couldn't access the assets. So you got to be careful how you design these, what the facts are, and how to customize it for your client. And again, thank you for joining today. My contact information is on the slide if you can see it on the last page. If not, Jonathan Shenkman will provide it to you. Feel free to reach out with any questions. And thank you for joining today. Jonathan, back to you.
Great. Thank you so much, Eli. And I apologize to the audience for the little bit of the technical issues here, but everybody's going to get a copy of the slide that were sent out this morning, so you could check out your email. Then they'll also be sent out tomorrow morning, so be sure to check your email, and everybody will get access to that. If anyone has any questions or wants to follow up about anything, feel free to reach out to Eli or myself, and I'll include his information as well in the follow-up email tomorrow morning. As I mentioned at the onset, the goal of these programs stay up to date on timely wealth management related topics and to collaborate where appropriate. I think we can all agree that the clients who are best prepared are the ones who are served by a team of knowledgeable advisors. 3 more quick items before I let you go. First, my fall webinar series continues on Thursday, September 22nd with Amy O'Hara, a partner at Littman Crooks based in Westchester, New York. She'll be speaking on the very important and timely topic of common errors in special needs planning. I'll send out an invitation to this and all my upcoming programs after the event. Second, please take 30 seconds to fill out my survey at the end of this program. It helps me improve my webinars and provide timely and interesting content to attendees. And I thank you in advance for that. Finally, if you'd like to be kept abreast of my latest articles, webinars, and all the other work that I put out, you can sign up for my free monthly newsletter. Simply email me with the word newsletter in the subject line. And with that, this concludes today's session. Please stay safe and healthy and have a wonderful day, everybody.